Welcome to the Animal Legal and Historical Center. Today we will present a video on the difference between a service, assistance, and therapy animal. The Animal Legal and Historical Center was established in 2002. We are based at Michigan State University College of Law under the editorship of Professor David Favor and Associate Editor Rebecca Wish. We are a digital law library, and we seek to present a variety of animal law information to experienced practitioners and the general public. In this video, we will discuss service animals, assistance animals, and therapy animals. Let's begin first with service animals. What is a service animal? A service animal is a dog that does work or performs tasks for a person with a disability. So who is a person with a disability? A person with a disability has a physical or mental impairment that substantially limits one or more major life activities. A service animal is allowed, under law, to go into public places like stores, businesses, government buildings, restaurants, museums, and public transportation where pets are not allowed. Take a look at the law dealing with service animals. The main law is a federal law known as the ADA, or Americans with Disabilities Act. This was a landmark law enacted in 1990. Under Title III of the law, no individual may be discriminated against on the basis of disability with regard to the full and equal enjoyment of public accommodations. Public accommodations include most places of lodging, recreation, transportation, education, dining, along with stores and other businesses. Regulations, which cover the day-to-day aspects of the act itself, specifically give individuals with disabilities who use service animals coverage. And since March of 2011, only dogs, and in some cases miniature horses, are recognized as service animals under the ADA. So how do I know if it's a real service animal? A service animal, again, is a trained dog and sometimes a miniature horse. No other animals are recognized. So if you see an iguana wearing a service animal vest, chances are he's not a true service animal. While the ADA does not require the animal to wear a vest or display a permit, the animal must be trained to perform work for his handler. Sometimes the training is not obvious with regard to certain service animals. So, what questions can a public place or business ask a person with a service animal? There are actually only two questions. Is the dog a service animal required because of a disability? And what work or task has the dog been trained to perform? Service animals perform many different types of tasks for their handlers. They may guide hearing or vision impaired people. They can provide mobility assistance by fetching items. They may even detect allergen in foods and other sources. They may assist in opening doors. And they may provide environmental assessments or physical counterpressure for those experiencing psychological symptoms. What about service animals in training, or SITs for short? Federal law, the ADA, does not give access to SITs. Instead, about 45 states have laws that allow SITs to accompany their trainers to public places while the animal is being trained. There are a few states without SIT laws. This includes Hawaii, Michigan, South Dakota, Washington, and Wyoming, but state laws change. Now let's talk about assistance animals and emotional support animals, a type of assistance animal. Under the Federal Fair Housing Act and another law called Section 504, an assistance animal is an animal that does work, provides assistance, or gives emotional support that alleviates one or more symptoms of a person's disability. Assistance animals are only allowed in housing. An assistance animal is viewed as a reasonable accommodation under the Fair Housing Act for a person with a disability, and it applies to most types of residences, such as an apartment, a condominium, or a single-family home. It would be similar to a person with a mobility disability asking for the reasonable accommodation of a closer parking spot than one that was previously assigned in an apartment complex. There are a few exclusions under the Fair Housing Act, such as an owner-occupied building with no more than 4 units, a single-family home sold or rented without the use of a broker if that person doesn't have more than 3 single-family homes at one time, or housing operated by organizations and private clubs that limit occupancy to its members. There are only 2 questions that HUD, the U.S. Department of Housing and Urban Development, the federal agency that oversees the Fair Housing Act, says that a housing provider should consider with a request for an assistance animal as a reasonable accommodation. Number 1, does the person seeking to use and live with the assistance animal have a disability? Does he or she have a mental or physical impairment that substantially limits one or more major life activities? And number 2, does the person making the request have a disability-related need for the assistance animal? In other words, is there a connection between what the animal provides and the disability itself? And of course, a landlord may request reasonable documentation, like letters from doctors or mental health practitioners, to determine and grant the request. An assistance animal can be either a service animal or an emotional support animal. Both are treated the same for purposes of the procedure for requesting a reasonable accommodation under the Fair Housing Act. An assistance animal does not require any formal training. However, it should be noted that an assistance animal is not a pet, and housing providers cannot charge pet deposits and pet fees, according to HUD. Assistance animal is not just limited to a cat or dog. A housing provider can deny an assistance animal if that specific assistance animal in question poses a direct threat to the health and safety of others. It must be evaluated based on that specific assistance animal and not a generalized fear about a certain type of animal. According to HUD, breed, size, and weight limitations must not be applied to assistance animals. So, where can an assistance animal go in a housing unit? Well, it really depends on whether the assistance animal is a service animal or an emotional support animal. An assistance animal that is an emotional support animal or not a service animal can go in all places of the common areas, like the lobby, banquet room, pool, those places where residents are normally allowed to go. A service animal can go to all of those places too, but it will also be allowed in areas where the general public goes, such as an on-site restaurant or shop. An ESA, emotional support animal, is not allowed in those public spaces. Assistance animals may also be accommodated in college dorm rooms. A 2013 court case found that dorm rooms and other college-affiliated housing were dwellings for purposes of the Fair Housing Act. Most colleges and universities have developed their own assistance animal policies for housing. Service animals and emotional support animals are also allowed for individuals with disabilities on planes. This is under a federal law called the Air Carrier Access Act. There are different rules for service animals and emotional support animals. Next, let's talk about therapy animals. So, what is a therapy animal? A therapy animal does not have a definition under federal law and under most state laws, but generally, a therapy dog is a dog used in an institutional setting for a particular purpose, like providing comfort or companionship. It does not necessarily need to be a dog. Very few states have laws on therapy animals. Alabama defines a therapy dog as a dog trained to visit and provide emotional support to children, the sick and disabled, the aged, and victims in the court system. New York says it is any dog that is trained to aid the emotional and physical health of patients in hospitals, nursing homes, retirement homes, and other settings, but that dog does not have access to public spaces like a service dog. Kansas distinguishes a professional therapy dog as a dog trained and tested to provide specific physical or therapeutic functions under the direction of a qualified handler. The term may not have a legal meaning in most states. And our last issue is about fake service and assistance animals. Can I get in trouble if I bring my pet to the grocery store? What if I put him in a vest that says assistance animal, or if I have a special harness on him? Well, remember, a service or assistance animal is not a pet, and an assistance animal is only allowed in housing. More than 30 states now make it a crime to fraudulently present your pet as a trained service animal to gain access or privilege to a public place. 5 states have created penalties to falsely claim that you need an assistance animal in housing when you don't have a disability. You can even be evicted. Thanks for watching our video. How do you find out more on this topic? Go to animallaw.info and you can find the following: a table of state assistance and service animal laws, a map of fraudulent service dog laws, all the federal regulations and laws related to both service animals and assistance animals, and a very detailed FAQ on emotional support animals and assistance animals in housing. Thanks for watching.